Possession of contraband within 1,000 feet of a church or school. Hey, how's it going? This is Alex Zouzelos, author of the book Courtroom Confidential. This is my fifth educational video on my new YouTube channel, Your Brain on Law. And I just want to say I'm trying really hard to be less wooden and more animated on these videos, so just bear with me if you would, and I promise it'll get better. So today I'm going to talk about an issue I researched about a year ago, which dealt with the question whether a person who stopped only for a civil traffic infraction within 1,000 feet of a church can be charged under Florida law with possession with intent to sell drugs within 1,000 feet of that church. Just a reminder, I'm not giving legal advice. I'm simply analyzing a situation which can occur and speculating how the situation can be addressed by a smart lawyer. The defendant, whom I'll call PC, was arrested for possession with intent to sell cocaine and cannabis within 1,000 feet of a church. I visited the area of the stop on Google Earth, and there was a church within 1,000 feet of where PC was stopped for the civil traffic infraction by a Sarasota County deputy, whom I'll call Deputy D. Immediately before the stop, Deputy D said he saw PC reach into the rear seat of the car he was driving, but that's all he saw PC do. Deputy D said when he walked up to PC's car, he smelled the odor of burnt cannabis. That led to the police searching the car, and in a backpack on the back seat, the cops found 9 bags containing 99 grams of cannabis and 10 bags containing 8.8 grams of cocaine. A passenger in the car, Mabel, told the police that the backpack was in the car when PC picked her up earlier that day. She said she didn't know there was drugs in the car. Just important are the things she didn't say. She didn't say that she'd ever seen PC in possession of the backpack. She didn't tell the police that PC told her the backpack was his, that there were drugs in the backpack, or that he had placed the drugs in the backpack or the backpack in the car. Neither PC's fingerprints nor his DNA was found on the backpack or the baggies that the cannabis and cocaine were found in, though I would add, even if his fingerprints and DNA were found on the backpack and baggies, that wouldn't demonstrate his knowledge of or dominion and control over the contraband, because he could have touched the backpack and baggies before the cocaine and cannabis was placed in them by someone else. This, of course, is relevant to a motion to dismiss based on the failure to show PC had knowledge of the drugs or that he ever exercised dominion and control over them, but I wasn't tasked by the attorney of record with moving for dismissal on those grounds. Rather, the issue I was hired to address, and which is the subject of this video, is whether PC could be charged with possession with intent to sell cocaine and cannabis within 1,000 feet of a church. So let's take a look at the arguments I made. One of the arguments was, regardless of the quantity of drugs, you can't say someone intended to sell them within 1,000 feet of a church when they were there only because that's where the police stopped them for a civil traffic infraction. Though at the time I couldn't find any cases in Florida directly on point, the Supreme Court in at least one other state has held that the mere fact that the police stopped a defendant for a traffic violation within, in that case, it was 1,500 feet of a public housing project, that was insufficient to support a finding that the defendant intended to sell drugs at that location. The case I'm talking about is State versus Hedge, Hedge, cited at 297 Connecticut 621, a Connecticut Supreme Court opinion from 2010. In Hedge, the police stopped the defendant for making a turn without signaling. The officers subsequently discovered a whole lot of drugs in the car, packaged for sale, as well as $59 in cash strewn over the car's center console and front passenger seat. The prosecution charged the defendant with unlawfully transporting cocaine and heroin with the intent to sell the drugs within 1,500 feet of a public housing project. The defendant moved for judgment of acquittal on the charge, claiming that the officer's detention of him near the housing project was merely fortuitous and that the state hadn't presented evidence that he intended to sell the drugs at that location. The trial court sided with the state, and it adopted its argument that the relevant statute didn't require proof of the intent to sell drugs in that excluded zone, but only that the defendant possessed drugs within 1,500 feet of that location with the intent to sell them somewhere. That doesn't sound right, and it wasn't, because the Connecticut Supreme Court reversed the convictions. In its analysis, the Supreme Court noted that the statute prohibited a person from transporting with the intent to sell or possessing with the intent to sell any controlled substance within 1,500 feet of a public housing project. Also, the act itself of transporting or possessing a controlled substance had to be with intent to sell or dispense within the prohibited zone. The court therefore held that the plain language of the statute required the prosecution to prove intent to sell or dispense narcotics within that 1,500-foot area. The court found that although the large quantity of drugs supported an inference of the intent to sell the drugs somewhere, it was insufficient to support a finding that the defendant had intended to sell the drugs within 1,500 feet of the public housing project. The court stated, mere possession of narcotics with an intent to sell at some unspecified point in the future at some unspecified place isn't enough. If a person is stopped while coincidentally passing through a location, there's no logical inference that he intended to sell at the location of the stop. Further underlying the court's decision in Hedge was the fact that the state hadn't produced any evidence that the defendant was on his way to the public housing complex, that he'd recently been there, or he'd done anything that would give rise to a reasonable inference that he planned to sell drugs within the exclusion zone. Moreover, the fact that the location the defendant was stopped at was known to be an area of heavy drug trafficking didn't establish that he sold drugs there or that he intended to. Furthermore, the cash found in the car didn't show intent because the money could have been there for any number of reasons unrelated to the sale of drugs, and even if the money was related to drug trafficking, there was nothing about that to suggest that the drug transactions occurred within that prohibited area. So let's take a look at the statute PC was charged under. And that was Florida Statute Section 893.13, which makes it illegal to sell, manufacture, deliver, or possess with intent to sell, manufacture, or deliver a cannabis or cocaine, any contraband, within 1,000 feet of a church which regularly conducts religious services. I went online and I checked the church out, and yes, the church was conducting regular religious services at the time that PC was stopped and arrested. There's no substantive difference between the statute the defendant was charged with violating in Hedge and the Florida statute PC was charged with violating. Both require the intent to sell drugs at a location within a certain number of feet of a designated place, in this case a church. Cases where defendants have been found to have violated that statute invariably involve the defendants actually engaging in drug activity in that prohibited zone. For instance, that was the situation in Fletcher versus State, cited at 168 Southern 3rd, 330, Florida 1st DCA 2015, and Lemaster, Lemaster versus State, cited at 162 Southern 3rd, 56, Florida 4th DCA 2014. But that wasn't the situation in PC's case. Like the defendant in Hedge, since PC was stopped for a civil traffic infraction while just coincidentally passing within 1,000 feet of a church, there's no logical inference that he intended to sell anything where he was stopped. Furthermore, there was no evidence that PC was on his way to the church, that he'd recently been there, or that he'd done anything that would give rise to a reasonable inference that he planned to sell drugs within 1,000 feet of the church. Furthermore, the fact that the location PC was stopped at may have been an area of heavy drug trafficking didn't establish that PC sold drugs there or that he intended to do so. Even assuming PC possessed the cannabis and cocaine in the backpack, all that supports is an inference that he intended to sell the cannabis and cocaine somewhere. It's insufficient to support a finding that he intended to sell the drugs within 1,000 feet of the church. This means that regardless of the quantity of contraband and the issue of constructive possession, the evidence taken in light most favorable to the state couldn't prove PC's intent to sell or even possess cannabis and cocaine within 1,000 feet of a church. In summary, then, the charge of possession with intent to sell cannabis and cocaine within 1,000 feet of a church had to be dismissed in PC's case because, first, there was no evidence PC intended to sell the drugs within 1,000 feet of the church, and second, his presence within 1,000 feet of the church was purely incidental to the police stopping him there. The next argument was that the small amount of cocaine, 8.8 grams, in PC's car is another factor militating for dismissal of the charge. The 8.8 grams of cocaine found in the backpack didn't establish PC's intent to sell it. In cases where small amounts of narcotics are found, courts generally require other proof of suspicious circumstances, such as the defendant's possession of drug paraphernalia, incriminating statements, or facts which circumstantially indicate an intent to sell. I'm citing Harris versus State, 72 Southern 3rd, 804, Florida 4th DCA, 2011. The state's evidence must be inconsistent with the theory that the defendant possessed drugs not for sale, but exclusively for his personal use. For example, in McCullough versus State, 541 Southern 2nd, 720, Florida 4th DCA, 1989, the defendant possessed a little over 6 grams of crack that had a street value of at least $150, according to the police. The officers never saw the defendant try to sell any of the cocaine. There was no evidence that the quantity of cocaine was greater than someone would possess for personal use, and the only testimony was the quantity was consistent with personal use. The court therefore concluded that the evidence didn't establish even an inference that the defendant possessed cocaine solely with the intent to sell it. The evidence raised no more than a suspicion of the defendant's intent to sell the cocaine, which doesn't cut it. Likewise, in Glenn versus State, 824 Southern 2nd, 1046, Florida 4th DCA, 2002, the 4th District Court reversed the defendant's conviction for possession of cocaine with intent to deliver because the evidence of the defendant's actual possession of 50 crack cocaine rocks weighing a total of 4 grams was insufficient to prove intent to sell. The defendant was standing alone near a convenience store and was never seen conducting any type of drug transaction. In Jackson versus State, cited at 818, that's 818, Southern 2nd 539, Florida 2nd DCA 2002, the defendant was found with 5 grams of cocaine packaged in 6 small baggies sitting in a larger baggie. The 2nd DCA reversed the defendant's conviction for possession with intent to sell, explaining this quantity, even as packaged, was not so large as to imply an intent to sell without other evidence. The court found it to be equally plausible that the defendant had purchased the 6 baggies of cocaine for his personal use, noting that individual packaging of similar amounts of cocaine had been deemed insufficient to show intent to sell in other reported cases. The court cited Nelson versus State, 707 Southern 2nd 405, Florida 50 ECA 1998, holding that evidence of 6 individually wrapped pieces of cocaine was insufficient to support conviction of possession with intent to sell. Williams versus State, 569 Southern 2nd 1376, Florida 2nd DCA 1990, vacating a conviction of possession with intent to sell, where the state proved possession of 10 pieces of cocaine, marijuana rolling papers, $72 in cash, and a weapon. And CLL versus State, 566 Southern 2nd 878, Florida 3rd DCA 1990, which adjudicating a juvenile delinquent of the lesser offense of possession of cocaine, where the evidence showed there were 10 pieces of cocaine in ring baggies, whatever those are. If anybody knows what a ring baggie, put it in the comments. I don't know what a ring baggie is. As with the other cited cases, the police in Jackson didn't see the defendant selling drugs. He was stopped solely because the car he was driving had a cracked windshield. In Valentin versus State, 974 Southern 2nd 629, Florida 4th DCA 2008, the defendant was charged with possession of cocaine with intent to sell within 1,000 feet of a publicly owned park based on his possession of 17 individual baggies containing 8.3 grams of cocaine, which a police officer testified had a street value of approximately $340. Again, there were no other facts which suggested the defendant's intent to sell the cocaine. Concerning the fact that the cocaine was stored in several different baggies, the court explained, discovering individually packaged narcotics does not automatically establish intent to sell. There has to be more than that. In Allen versus State, Allen is spelled Alleyne versus State, 42 Southern 3rd, 948, Florida 4th DCA, 2010, the defendant had 18 individual plastic bags containing marijuana, which had a combined weight of less than 20 grams. The police didn't see the defendant selling or attempting to sell the contraband. Rather, all the defendant did was run away when several police cars pull up to a convenience store the defendant was standing at. The state attempted to distinguish the defendant's case in Allen from the facts in Valentin by emphasizing that one of the officers adamantly testified in Allen the defendant intended to sell drugs. However, the court rejected this argument, noting, other than the manner in which the drugs were packaged, no other facts supported that conclusion. The officer's opinion was unsupported by facts that would give it credibility. Allen did nothing outside the convenience store before the police pulled up, which indicated he was selling drugs, and neither the total amount of marijuana nor the amount of cash recovered was inconsistent with personal use. In Harris, a police officer saw the defendant in a city park holding a clear plastic baggie containing what looked like crack cocaine. I cited Harris earlier in this video. When the defendant saw the officer, she turned away from him and hid the baggie in her hand before shoving it down her slacks and walking away. Does anybody use the word slacks anymore? If they do, put it in the comments. I don't think they do, although I just did. Anyway, the police found 40 to 50 pieces of crack in the baggie. Like the other cases cited, the court noted the small quantity of drugs seized and the absence of any evidence showing the defendant was selling drugs in the park as facts which were critical to its determining there was no evidence of the defendant's intent to sell cocaine within 1,000 feet of a city park. In PC's case, the evidence was insufficient to show PC intended to sell cocaine or cannabis within 1,000 feet of the church. The small quantity of cocaine, 8.8 grams, in the backpack was as consistent with personal use as it was with an intent to sell it. Moreover, the police didn't see PC selling or attempting to sell cannabis or cocaine within 1,000 feet of the church. PC was there only because that's where the police stopped him for the civil traffic infraction. Neither PC nor his passenger Mabel said that PC intended to sell cannabis or cocaine in the area of the church, and no contraband was found on PC. Consequently, the evidence was insufficient to prove that he was dealing drugs. Moreover, the 99 grams, a little less than 3.5 ounces of cannabis found in the backpack, was also insufficient to prove that PC intended to sell it. That amount was just as susceptible as proof of personal use as it was to an intent to sell it. This larger quantity, I looked this up on the internet, this larger quantity is often sought after by, they use the term seasoned users, or those who prefer to stock up, ensuring a long-lasting supply for continuous enjoyment. You never know what's going to happen. Furthermore, since there was no proof that PC sold or attempted to sell the cannabis within 1,000 feet of the church, the evidence was more consistent with personal use of the cannabis. Even if it's assumed PC intended to sell the 3.5 ounces of cannabis, the evidence was insufficient to establish when and where he intended to do so. In State versus Calfat, spelled Kalphat, cited at 134 Connecticut Appeal 232, Connecticut Appellate Court 2012, a Connecticut Appellate Court, how many times can I use that phrase? I use it, 3 times in the last 1.5 seconds? Anyway, I'm going to use it again. A Connecticut Appellate Court found that although a jury might reasonably have inferred that 10 pounds of marijuana seized from the defendant's home would be repackaged for sale, the record was absent of any evidence from which the jury reasonably could have determined the precise location or locations of any such sales. Consequently, the jury only could speculate about the precise location. The defendant's conviction for possession of a controlled substance with intent to sell within 1,500 feet of a public school was therefore vacated. Last, nothing PC did prior to the stop was consistent with a person trying to buy or sell drugs on the street. In State versus Regan, Regan, 564 Southern 2nd, 1208, Florida 2nd DCA, 1990, there was no nexus between the crime and the school where an undercover police officer was deliberately standing for the purpose of enhancing the penalty. There was no evidence the defendant knew he was within 1,000 feet of a school, and no indication that the defendant intended to sell or give cocaine to a minor. Thus, the court concluded he couldn't be convicted of possession with intent to sell within 1,000 feet of a school. Those are my thoughts on this very interesting issue. Feel free to comment on my video. Comments always generate interesting discussions. Subscribe to my channel, and if you're a lawyer, consider hiring me to research legal issues and draft pleadings under your supervision. My contact information is below. Thanks for watching, and I'll see you next time.